to look at that. The other perspective, which I think is important, is that there is, a lot of complexity in regard to the target subject matter area. So, there's hardware, there's communications, navigation, pharmaceuticals and biotechnological processes, transportation, fabrication, software for many of those things, tax and financial business methods. How are we going to distill this down? Well, the patent office has kind of helped us do that. There is only one manual patent examination procedures. Now, there are nuances within some of the, descriptive matter there that target different areas. But what we're going to try to do is break out the 85%, which is universal to all subject matter areas. And then we'll talk about the enablement and the 15% and how that factors into different disciplines. But it's very clear what the implications of that are. So that's one aspect of the IQ, to just know that there's some common ground here, no matter what subject you're in. Another objective we have is to really kind of transcend the barriers of complexity that the patent examination process holds for your team. And you see your team here behind the Chinese wall, and the chief counsel or your IP counsel and the patent examiner is the shamans who are guarding the patent examination procedures on the other side of that Chinese wall. And what we want to do today is move you over here so that you're all talking around the same framework and circles. So we're going to get into this a little bit, as far as some of the specifics. Again, we're still on this kind of journey and baseline, and we're almost at the end of this section. But just to put it in a hierarchical kind of framework, you have the object of your invention, which is the instance of the innovative thing that you have. Then there's this decision about whether is it patentable or not. That's Rule 101. And there are 5 different kinds of things there. Then there's 5 different types of protection you can get. We're going to focus on the utility patent. And then within that, there's 5 different types, and then there's 5 rules. So as we go looking at this a little bit, this is the way to visualize that. Inventing into the IP zone, and again, I'm keeping that red color to kind of quantify what it means to be in the heart of this IP zone with a great patent application, is the IP. So IP types: design, patents, utility, plant, pet, trademarks, copyrights, and so forth. Okay. So 101 means that you can have an article of manufacture, software, machine, composition of matter, process, which again is the conventional process, software transformation, business method, or internet process, and then any new uses of any of these below. That's defined by Rule 101 and 102 and 103. 101 defines what those are. 102 and 103 define novelty and unobviousness. We'll go into that here. And 111, 112, 113, the actual transformation into a patent application. So what we're extracting from is the grant from the U.S. Constitution that says Congress has the power to promote the progress of science by letting inventors have the exclusive right to their respective writings and discoveries. We're not going to cover all these laws. What we're going to do is really just focus on these. And in saying these, what we've said before, the reason I'm mentioning these, I want to try to explain them in simple terms that allow for insight into how to do an invention disclosure. So again, before and after AIA, these were the rules. It's just how you use these today versus on March 12th of 2013 really are fundamentally different. And that's the most important point I want to convey. So the workbook for this includes this definition and work process stuff and examples of how these are applied as we go through this. So don't worry about this if it seems like there's too much here to comprehend at the first blush. But what you want to do is you just think in terms from an inventor's point of view. 101, 102, and 103 define what can be patented. Now look, you could patent a spoon, but the reality is that they may not pass rules 102 and 103. So even though something falls within 101, the categories of what can be patented as by the star, what constitutes novelty and unobviousness, which is 102 and 103, really set a bar for what will get through the examination on merits. So if you get rejections for 102 and 103, you will not be examined on the basis of the application itself and what its content is. 111, 112, and 113 are important, but 112 is the key to the door. 111 basically defines what the package that needs to be submitted is, and it separates out what a provisional patent is. 113 factors on the drawings, and the combination of 112 and 113, which include what we call definiteness, full enablement, antecedent reference, and delightful usefulness, all need to be considered in the step of making your disclosure. So the perspective we're going to bring to this process and what we're going to talk about is actually going to factor in the idea that at the end of the day, a patent application is a patent application, and it looks a certain way. It has sections 1 through section 6, the abstract background summary, description of the drawings, description of the invention, and the claims. We are going to reverse engineer this and separate the before and after AIA as we dig in a little bit further. So what we're going to do is have a look at the disclosure process from the point of view of how to make sure we have novelty and unobviousness, and that's the 85%, along with antecedent reference, and then the enablement and unexpected outcome, which is 15%, is unique to each subject matter and niche quality. So that's not. So at the end of the day, if we start with the fact that the issued claim is the only thing that matters, so again, using a metaphor, what we want to